Hello, everyone. Thanks for joining us. My name is Bill Kessler. I am the chair of the litigation group at Beresford booth, and this is a webinar on the confluence of a few statutes, the damage to land statute, which is RCW 4.24.630, the timber trespass statute, the adverse possession, the doctrine of adverse possession, ejectment, quiet title, boundary lines generally. The confluence of all of those things and how insurance pertains to them. Move the slide forward here. So here's our topics. We're going to do an overview of the adverse possession doctrine and ejectment, and then damage to land and timber trespass. And we're also going to talk about those in the context of insurance coverage, and then we'll use a litigation example to talk about litigation strategies. But I'm not going to go too deeply into adverse possession, damage to land, and those related doctrines. There's a lot of coverage already on our firm's website and elsewhere about those topics, but we'll talk about them in the 35,000 feet. So here are some links from our firm's website about discussions of boundary line issues generally, and damage to land, timber trespass generally. We've got other links on our website. We've been putting out a lot of content since the beginning of COVID, and we continue to do that. So I'd encourage you to check out some of the pieces that we've got for a deeper dive into adverse possession, damage to land, ejectment, timber trespass, that sort of thing. We'll start with adverse possession and a bit of an overview of it. So I'll use an example where you're taking your neighbor's land. If your neighbor is not using a portion of land and you are, and you do that in a manner that is open and obvious, so open and notorious as the law calls it, you do it continuously, exclusively, and you do it in a manner adverse to the interest of a reasonable true owner, and you do that for 10 years, then you become the owner of that land. So open and obvious, that would be like your building existing on their property, or a situation that I've had. Continuously, obviously that means without interruption, small interruptions that would be normal for a normal owner to have an interruption in use of land. That doesn't break the continuous chain, but in general, the use has to be continuous. You have to be the only one if you're adversely possessing your neighbor's property. It has to be exclusive, so you're the only one doing it. And the way in which you possess that property has to be in the manner of a reasonable true owner. So you're treating that property in a way that a reasonable owner would say, hey, if they saw you using the land in the way that you're using it, they'd say, hey, get off my land. What are you doing? That's my definition of a reasonable true owner. And you have to do all of that without the initial permission of the true owner of the land. So if there's midstream permission, that does not break the chain of adverse possession. If you've already established and have a term of use of that permission, or sorry, term of use of that of your use, then midstream permission doesn't break your adverse possession chain. But initial permission, if you started using it because your neighbor said that you could, then you never started the clock of adverse possession. Anyway, all of that has to be, again, 10 years straight. So now let's pivot a little and talk about the damage to land statute and the timber trespass statute. So here's RCW 4.24.630. Your neighbor is liable if he or she wrongfully causes waste or injury to your land, or wrongfully injures personal property or improvements on your real estate. Classic example, someone tears down your shed, someone excavates in your yard, lays sewer pipe or something across your yard, repairs lines that they don't have an easement to repair, things like that. And we'll talk a little bit about that in this litigation example later. So the damage to land statute it's an attractive claim to bring for plaintiff's attorneys because there's triple damages available, treble, plus attorney's fees. And distinguish that though from timber trespass. Now, a lot of attorneys will know that timber trespass has treble damages available as well, but it doesn't have an attorney's fees clause. So if you're if you've been injured and the only damage that you've suffered is to your trees and not to the rest of the land, then you've only got a claim as to triple the value of those trees as determined by a professional like an arborist. But you can't double dip and go get that waste statute treble damages plus attorney's fees. This is usually a big deal in cases like this. So let's talk a bit about insurance coverage. So the adverse possession, claims of adverse possession, if you're bringing that claim, that is not generally covered by your homeowner's insurance policy. And if someone's bringing that claim against you, it's also not covered by your homeowner's policy, almost never. A lot of people think, well, if someone's encroaching on me, I've got a title insurance policy. So if my neighbor makes a claim that he or she owns a portion of my property through adverse possession, then I tender that to my title insurance company and they cover it. No, very rare that a title company will cover an adverse possession claim or an ejectment claim, because those are specifically excluded by most policies unless you have an extended policy. An extended policy is one where you get a survey before you even close the purchase, before you even get the policy of title insurance. You get this extended policy, and to get the extended policy, you need to have a survey. The survey reveals whether or not there are encroachments, and if you have encroachments, you don't get the extended coverage. And almost nobody in a regular residential or even like light commercial context has extended policies. So here's the thing, though. Defense, if someone claims that you have damaged their land, those claims are covered by your homeowner's insurance policy. Your homeowner's policy is a general liability policy that covers injury to people and property. So your neighbor sues you, claims that you've damaged their land, and that is going to be covered. Almost always that's going to be covered. Same thing with a timber trespass claim. If your neighbor is claiming timber trespass, that's going to be covered. So what you'll see a lot of times is attorneys trying to make damage to land claim anytime they're going to defend against an adverse possession or ejectment claim. If there's any way to make a damage to land claim, they want to do that because they'll get triple damages. They say, okay, we're going to counterclaim here and we want to get triple damages, or the plaintiff is going to say, well, I've got an adverse possession claim here, but I want to claim damage to land or timber trespass, especially damage to land with that attorney's fees clause in it, so that I can trigger attorney's fees. But that's not always the best strategy. So let me give you an example. Let me just slide along here. So I'll give you an example from several years ago that illustrates the point I'm making. So we had a case where we had two large bluff homes in Seattle, and our client had the home to the west, the neighbor had the home to the east, and the neighbor encroached on our property. And so, and the neighbor was not suing yet, but claiming adverse possession. So we didn't think that that was a very good claim. We thought that the neighbor's claim was didn't have much merit, and we were preparing to sue the neighbor for ejectment. So that, if you'll recall, it's the get off my land claim, the opposite of adverse possession. And the neighbor knew that that was probably coming. And the neighbor was, we had a suspicion that the neighbor was house rich but cash poor. And before we sued, but while I think the neighbor knew it was coming, he sent over a crew essentially to excavate this big hole in the area that he claimed it wasn't a huge hole, but it was this excavation project. It was ridiculous. And supposedly for the purpose of landscaping the encroachment area that he claimed that he owned through adverse possession. And that happened as we were at the front end of preparing the complaint. And I was talking to my client and I explained RCW 4.24.630. And I said, well, this could give us a route to recovery of attorney's fees, but probably only attorney's fees pertaining to the portion of our claim related to the excavation that this guy's done, not the portion of our claim related to adverse possession ejectment, which was the vast majority of course, what our claim was going to be. And this claim under 424.630, the reason I explained this to my client, and I said we could do this, but I said we shouldn't make that claim because we're going to give him a free lawyer. He's going to turn around and take that claim of 424.630. He's going to tender it to his homeowner's insurance company. He's going to say, hey, my neighbor is suing me and claiming that I damaged his land. And then that insurance company would step in and would then assert his adverse possession claim against us. If he would pay his deductible, that's all he would pay. And those attorneys would take, the insurance company's attorneys would take that entire claim the whole way forward, because adverse possession was a necessary element of his defense. There was no argument that he wasn't claiming that he didn't do the excavation. He's admitting he did that. He's saying, I did excavation on land that I already owned through adverse possession, so I'm not liable. So his insurance company would have had to pick up the mantle for the entire lawsuit. And so now the fact that he's cash poor and house rich wouldn't hurt him. And as it was, we wanted the ability to exert financial leverage to settle this lawsuit reasonably and get it to a successful conclusion. And so we sued for ejectment and quiet title, but we did not sue for damage to land. We didn't sue for 4.24.630. And I think that threw him off a little bit. It took him, once he got served, he had 20 days to defend, and he only appeared to defend on day 19, even though I knew he had counsel, because I think they were trying to figure out a way to get insurance to pay it, but insurance didn't pay it. So the point is, there are, in all of these claims pertaining to boundary lines and damage to property, be it RCW 4.24.630 or be it timber trespass, those things blend together frequently. And oftentimes there are insurance coverage issues that need to be analyzed at the outset of the case, whether you're the plaintiff or the defendant. And there are actions that can be taken to make sure that you plan for that in advance. So important to talk to counsel at the outset of these disputes to understand what your options are and the financial realities and pluses and minuses of different strategies. So any questions, please give us a call, and thank you much for watching.